Please be seated. All right, everyone. Before we begin this proceeding, I wanted to just remind everyone that the court has issued an order on decorum for today, and there are certain rules that are in effect for this hearing for everyone. All participants, all spectators, all media. This is a sensitive matter, and just to remind media, there should be no videography of any of the defendant at all in this matter in any of the gallery. We have to preserve not only the juvenile's rights, but also the rights of any victims that are present here today as well. There shall be no outbursts in this courtroom. We need to preserve decorum, and so please comply with the rules that have been posted and provided to you prior to this hearing. Attorney Newell, would you be able to call this matter? I would ask that the parties refer to the juvenile with the initials for us to proceed, and then give the appearances. Thank you.
Yes, Your Honor. This is State of Wisconsin versus CP-B. As yet doesn't have a case number. The state will be filing the criminal complaint as soon as I'm done, I guess, introducing the case. Wade Newell, District Attorney for Chippewa County, appearing on behalf of the state. The defendant is at JDC with his attorneys Kirby Harless and Carl Schmidt, all appearing via video.
All right, Attorney Harless, first of all, there has been a criminal complaint that has been filed or provided.
Actually, it will be filing that now.
Please approach. And Attorney Harless, have you been able to receive a copy of that criminal complaint and discuss the charges and maximum penalties with your client?
We have, yes, Your Honor. We would waive any further reading. We would waive the time limits for a preliminary hearing, which we have discussed with our client, and we are requesting that it be set for a hearing next week. I believe there's still decisions to be made as to counsel moving forward, so I'd like to have it delayed for 1 week in order to have counsel permanently assigned and make a decision from scheduling from there.
All right. Attorney Newell, did you have any arguments on bond for this matter?
Yes, Your Honor. The state is requesting a $1 million cash bond with the condition that he have no contact with any juveniles and not possess any dangerous weapons. The state understands the state is asking for a very high cash bond for a defendant of 14 years of age, but given the statements that the defendant made to law enforcement that his intention was to rape and kill the victim from the get-go when he left the house with the victim going down the trail, the state believes that there is a need to protect the community and also a concern regarding the defendant fleeing. Given the severity of the punishment he is facing for all three of these charges, that gives him a very big incentive not to resolve the matter and to flee the area, but the protection of community also is necessary in this case, given his statements, once again, regarding his intentions and also his statements regarding the fact that when he did get off of the trail, punched the victim in the stomach, knocked her to the ground, essentially strangled her, hit her with a stick before strangling her to the point of death before he then sexually assaulted her. Based upon all that, the state believes that a $1 million cash bond is appropriate with the two conditions outlined.
All right, Attorney Harless or Attorney Schmidt, any objections?
Yes, Your Honor, to the cash amount. This is Attorney Schmidt. I'll be addressing the bond argument. We're asking the court to impose a $100,000 cash bond. We agree that cash is appropriate in this case. The charges are extremely serious. We do not feel that setting bond in excess of $100,000 is necessary or appropriate in this case. We do not believe that Mr. PB is a flight risk. He is 14 and an 8th grader. He cannot drive. He is not in a position to raise much money, frankly, at all on his own. He resides with his mother. He is a lifetime resident of Chippewa County. We believe that a $100,000 cash bond should be adequate to ensure that Mr. PB does not flee, that he has a realistic opportunity for some sort of pretrial release, as limited as I think that would be. I believe that in light of his age and that circumstance, that setting that bond any higher than $1,000 is far beyond what's necessary to serve the goals of bail. I think that all it would do would be essentially to index his taste at the details of these offenses. That's all. Thank you.
All right, thank you. All right. The court has considered the arguments of counsel here today. This is a serious charge, and because of serious charges, there are serious consequences, which gives a greater incentive for individuals not to want to return to court when they are facing those charges. And so I also need to consider the threats to the community. The information that was disclosed by the district attorney shows that this was a serious threat to the community, and so the court is concerned that this could be a further threat if the individual was no longer in custody. The court will order a $1 million cash bond with the conditions that the defendant not contact any juveniles and have no dangerous weapons. Attorney Harless or Attorney Schmidt, I'm not aware of whether or not the defendant has any siblings that I could accept this from that could be supervised. I would allow that to have supervised contact between any family members that are his siblings, as long as that contact is supervised. The time limits for the preliminary hearing have been waived. However, there is a request for a hearing next week to determine whether counsel would need to be updated for the defendant. I have some dates. At this time, I would like to go off the record to go through our calendars to make sure that there would be time that works for the parties. We are off the record. Attorney Harless, I have next Thursday, May 5th. I can do a time between 3 and 4:30. And Friday, May 6th, a time between 8:30 and 10 a.m. Do any of those times work for you for the defendant?
3:30 on Thursday sounds like it would work well.
Attorney Newell, does that work for you?
3:30 on May 5th, yes, Your Honor.
All right. We are back on the record in this matter. We have set a return hearing in this matter for 3 p.m. on May 5th of 2022 to address the issues raised by counsel in this matter. I do need to comply with our constitutional amendment known as Marcy's Law as well. Are there any victims present who wish to speak in this matter?
Not to my knowledge, Your Honor. One thing is, at the same time as filing the criminal complaint, the state has also filed the victim key. I would ask that that be filed confidentially and sealed, only available to the parties.
All right. I'm going to do a few things here. Were there any issues from any victims or victim representatives regarding the schedule of next week's hearing at all? All right, hearing none. I will order that the clerk file the criminal complaint that was recently given to the clerk here at this hearing, that criminal complaint be sealed and available to the parties. If for any reason that this is released to anyone that is not a party, that the clerk redact all references to the name of the defendant. However, in the caption of the criminal complaint, the clerk shall keep the initials of the defendant. All future filings in this case by all parties and all representatives of any party, including attorneys, shall use the defendant's initials going forward. Attorney Newell, were there any other items to address for today before we meet again next week?
When the court ordered the bond condition made the reference to any siblings that need to be excluded, was there a response to that?
I did not hear anything. Attorney Harless, was there a sibling of the defendant that we may want to add an exemption for under the bond that he may want to visit with supervision?
Yes, there are siblings. I'm sorry, I thought the order was just being made to allow for the supervised visitation with siblings.
Any objections on that, Attorney Newell?
No, Your Honor, as long as supervised means that there's another adult in the room and that he not be alone even with his siblings at all.
I agree. I think that should be supervised through any law enforcement or any professionals through the JDC if that's where he will be retained until further order. Attorney Harless, was there anything else, or Attorney Schmidt, anything from your side that you wanted to make for the record today?
Just a clarification on scheduling. It was my understanding that we were setting this for 3:30, and then when we went back on the record, the court indicated 3 o'clock. I just want to make sure I got my calendar right.
All right, 3:30 works, Attorney Newell?
Yes, Your Honor.
All right, let's set it for 3:30 then on May 5th for the next appearance in this matter. And I would ask the state to set up video for that date as well if the defendant is still remaining at the JDC.
And because that is one of the required court appearances, or I guess no, it's just a status, so it's not required. Never mind, Your Honor. I guess we did not deal with today as the defendant had the right under the statute to appear in person. We didn't, I guess, address that up front. It may be good to address that now to make sure that the defendant is okay with this hearing having been done via video and not in person.
Under recent law, Attorney Harless and Attorney Schmidt, all proceedings and criminal proceedings are able to be conducted by video, including this one today. Was the defendant agreeable to having this matter conducted by video with him appearing from the JDC with counsel present with him rather than here in the courtroom?
Yes, he had no objections to that. He was fine with it being that way.
All right, then I will find that the defendant made a knowing, voluntary, and intelligent waiver of his right to be present for today for us to continue the hearing here today. Anything else today, Attorney Newell?
No, thank you, Your Honor.
Attorney Harless or Attorney Schmidt, anything else?
No, thank you, Your Honor.
All right, I will ask the clerk's office to prepare the bond and send that down to the JDC for it to be signed, and then we will see everyone next week, May 5th at 3:30. All right, thank you all. I'm going to hang up.
Thank you, Your Honor. Thank you.
All right, at this time, to everyone who is present, please be orderly as you exit the courtroom. Room 226 has been set up for any further interviews or press interactions with any parties. So I would ask that the press please exit the courtroom at that time for those purposes. Thank you all. We're adjourned.